Yes.
But
Yes.
we have done some consultation here.
Okay.
You have the leader of the bank.
Yes.
In the name of the Attorney General, Professor Githu.
Yes.
And he wants to address you on
Yes.
jurisdiction.
Okay.
And I'm quite happy to let him go before me.
Sounds like it's in good order.
Thank you very much, Mr. Attorney. My lords, I have come here today at your invitation, and it's my great privilege to be in this court. On the 23rd of June, you invited me to join these proceedings. I assume, my lord, in the hope that I might tell the court something of some value to assist you in determining the matters before you. After I read all the pleadings, my lord, I came to the conclusion that I would like to address you on only 2 points, and very, very briefly in respect of those 2 points. But before I do so, my colleagues have, in a very erudite manner, explained the background of the controversy now before the court, and I will not seek to repeat any of that, except, my lords, I'd like to draw your attention to the fact that this election that we anticipate in August has been the subject of unprecedented judicial attention, because there have been very, very, very many cases. I think at the last count, there were, from my office, close to 30 cases relating to several aspects of this election. Indeed, there have also been extrajudicial processes affecting this election. We started last year with calls to disband the commission that was then in office. I was very involved in that process as advisor to the government, and after very long and protracted deliberations between the parties, we disbanded that commission at the behest of the applicants now in court. We then went through a process where again, the applicants stated that they were not confident there would be a fair and free election if all the election laws were not reviewed and amended appropriately. Again, we went through a very, very long consultative process. My learned colleague and friend, James Orengo, co-chaired a parliamentary committee with Honorable Kiraitu Murungi. And again, following that very, very long process, the election laws were amended. In fact, they were amended in an unprecedented manner in the history of legislation in this country, because the bill, as agreed upon politically, was never subjected to any debate. The political compromise was there will be no comma, no full stop, no change whatsoever. Again, this was accepted, and we moved on. But again, began another collateral attack on the 2017 election. This one became how IEBC, the new IEBC, my lords, I want to remind you, we have now created a new IEBC. It came under renewed attack by the same parties as to its independence, as to its integrity, as to its competence, and as to its manner of handling the election. So we saw many cases, my lords, before various courts. One said that the voter register cleaning up process by an audit firm, KPMG, had to be stopped. for various reasons. That was argued for several days. Luckily, your lordships determined that in good time, allowing KPMG to advise on the voter register. Some other cases went to the use of technology, the transfer of staff, and now we are here on the printing of the ballot. Why do I give this history? Because I want to suggest to you, my lords, of the 2 points I want to make, the first one is that to the extent that this court is a judicial review court, its jurisdiction has been invoked in error and contrary to law and binding precedent. That's my first point. To the extent that the reliefs sought by the applicants are judicial review reliefs, including certiorari, mandamus, and prohibition, the jurisdiction of this court has been invoked in error and in vain. Secondly, and finally, I want to make the argument that the election scheduled for 8th of August 2017 is of such profound constitutional significance in the political life of this nation that it ought not to be interfered with in the manner suggested by the applicants, because to interfere with that date, and I am suggesting that if the orders sought are granted, that date will be vacated. If that date is vacated, this, our republic, will be thrown into a constitutional crisis of profound and unprecedented nature. And I'll sit very, very briefly to demonstrate that in a short while. My lords, this constitution is referred to by my learned friend, my learned colleague and friend, Honorable James Orengo, as if it were a procurement statute. The Constitution is not a it's not a procurement statute. It is not to the Constitution that we turn when we wish to determine whether a procurement has been done properly or not. We turn to the procurement law. And that procurement law is a law that is promulgated by Parliament in furtherance of the principles set out in the Constitution itself, as to fairness, as to openness, as to competitiveness, etc., etc. My lords, when I have read through all the documents presented by the applicant, I came to this conclusion. The mandate of IEBC as an independent constitutional organ to conduct elections, and before doing so, to procure the material necessary for that purpose, has not been contested. It has not been suggested that IEBC has no constitutional or legal authority to buy the material it needs to conduct the election. What is attacked is not even the process itself. That is to say, it is considered by the applicant that IEBC can single source a supplier, and that would be consistent with the Constitution and the law. In fact, it is further considered or rather, it is not, the applicant does not raise the question as to whether or not the party awarded this contract is incapable of making the supply. So what then is the complaint? The complaint is that for many, my learned colleague, my junior learned colleague said, an impression has been created, a perception has been created. So we have a case that relates to impressions and perceptions about the ability of the contractor. So what are you, my lords, being asked to do? You are being told at the end of the day, this contractor is a bad contractor. This supplier is a bad supplier. Why? Well, there are many reasons. I don't want to go into them. I think Mr. Karori has gone into them. But what does that then mean in law? You are being told not to look at the process, which is what the judicial review jurisdiction is about. You are being asked to look at the merits of the decision. You are not being asked to look at the process of the award of the tender. You are being asked to look at the merits. My lords, I will not waste your time going through all the numerous cases where you have said over and over and over again that this is not the job of this court. You have said over and over and over again, except that I would like to read one where I think the Honorable Justice Odunga was involved, where the court is saying the judicial review function is a function about process. It is a function about process. It is not a jurisdiction where the court substitutes its own judgment for that of the body that the Constitution, in its wisdom, has granted the mandate to do something. When my lords prepare to make your decision, you will read through, I urge you with respect, of those cases that I have put there from this court, speaking in a very, very clear language. When this judicial review jurisdiction has been abused, the consequences are very, very serious. We have had situations where students who don't pass the exam, say at the Kenya School of Law, I hope that does not offend some of those assembled here, they go to court and say, we want mandamus to direct the principal to confirm that we have passed. That is to invite the court to mark the exam and to declare that the students have passed through a court order. That is an abuse of judicial review. Judicial review cannot do that. Sometimes other students say, We are graduating on Friday. The list has been published. We are not in the list. Give us mandamus for the university to put us in the list. That is an abuse of judicial review. Judicial review must be confined to this. Why you accorded an opportunity to sit the exam? Yes. Was your mark disclosed to you? Yes. Did you pass the exam? No. Did you take the supplementary? No. That is the correct inquiry that a court must make, and I don't want to overstate that point. Let me come to my last point, my lords, before, and this is to suggest, my lords, I know that we have a transformative constitution. We are all very proud of it, all of us. Those who helped to write it, like myself, with some humility, my lord. Those who applied, like yourselves, my lord, every day. Those who litigate it every day, like my colleagues here. We're very proud of this constitution. And we have all agreed we must give it a robust, purposeful, meaningful, flexible interpretation. But I urge you, my lords, to remember that because law is rendered in language that is clear most times, that is ambiguous sometimes, the only way to retain fidelity to law is to give language the meaning that it naturally has. And therefore, there is a case to be made, my lords, for a philosophy of judicial restraint. Judicial restraint. Not judicial cowardice, not running away from controversy, my lords, not temerity, not timidity. That's not what I'm saying. I'm not saying that judges must avoid controversies, stay in the straight and narrow and non-controversial, no. But I'm saying a philosophy of judicial restraint is a philosophy where the court, and you have done this on numerous occasions, my lords. Mr. Justice Odunga in particular, if I say with respect, has several judgments here, some of which I have quoted, where he's saying, if the Constitution clearly mandates an organ to make decisions, that discretion of that organ ought not to be unduly interfered with unless there is a clear violation of law. I commend this judicial restraint philosophy because what it means is that we are then able to allow institutions like IEBC to do the work that the Constitution intended for them. Let me come to my second and last question. Why do I say, my lords, that if the orders granted, if the orders sought by my colleagues who are granted, our nation, our republic, would be placed in a very, very serious constitutional crisis? It is because, my lords, IEBC has told us, and it is empowered by the law to tell us, how long it needs to prepare for the election. Mr. Ezra Chiloba's affidavit speaks very clearly to this point, indicating the timelines that they require in order to have the ballot in place by the 8th of August. I want to suggest, my lords, with respect, that we should be very wary of second guessing an expert institution. One of my learned colleagues here suggested, why do they need 7 days? Let's give them 3. Take 3 here, take 2 here, take whatever. It's enough time to do a new tender. I don't know whether we would want to live with the possibility, my lords, that come the 8th of August, there are no ballot papers, because the 2 days we took, 4 days we took, resulted in the total failure of the printing. Which brings me to my point. What would happen? What would happen if we didn't hold the election on the 8th? First, because this is cast in stone, and I took some credit for being among the writers of the Constitution, let me now take some responsibility for what is clearly a very foolish decision that was made to write the date in stone. It was the wrong decision. Why? Because after the 8th of August, if we do not have the election, Article 134 kicks in. Now, my lords, Article 134 means that government is completely hamstrung. It's completely hamstrung. In fact, the only organ that will be functioning will be, my lords, with respect, the judiciary. The executive will be at half-mast for the reasons that are set out there, and I don't want to waste your time by reading it. Indeed, after the 8th of August, the government is really a caretaker government until the new process of renewing government anticipated by the Constitution kicks in. So I want, therefore, to suggest that it is such a radical measure in any way to imperil the date of the 8th of August. And I want to say, my lords, before I sit down, that there is no case that has been made out that comes anywhere close to creating such an alarm among rightful thinking members of our society that something so horribly wrong will result from this ballot being printed in the manner that is now ongoing. In fact, I hope I have demonstrated that something horribly wrong constitutionally and politically would result with an intervention that changes those dates. And one last legal point before I sit down and donate 5 of my minutes to 15 of my minutes to Mr. Ngatia, who, my lords, as you know, is a much more loquacious man who requires to say more. I want to say this, my lord, as a legal point. Supposing, for purposes of argument, my lords were totally persuaded by my learned senior, Honorable James Orengo, and his very distinguished colleagues, that IEBC did something wrong. Did something wrong. It is still my very, very humble submission that that would not entitle the applicants to the remedies that they seek. Because, my lords, the law is trite. The jurisprudence is trite. The jurisdiction they have invoked is a discretionary jurisdiction. So that my lords may agree with everything they have said. And then at the end of the day say, we decline to exercise our discretion in your favor in the public interest. And what is the public interest? That an election, an important election, must be held and held on time. So it is my very humble view, my lords, that for those two reasons that I have alluded to, I would respectfully submit that your lordships should dismiss this application. And as far as the Attorney General is concerned, I wish no costs from this. I thank you. I have donated, my lords, if you please, to Mr. My lords. My learned friend, Mr. Orengo, has certain views about time, but I think it's your lordship's discretion.
Let's hear what you have to say and then see if we'll enlarge time, Mr. You're not next anyway, it's Mr. Gatanji. Yes.
Yes, I'm next.